Good afternoon, everybody. I'm back. Sorry about last weekend. I couldn't be in two places at once, so unfortunately, I had to miss last week's live. This week, obviously, we're going to have a lot to get through, and I don't have my trusty assistant that types up all the questions for me that scroll up the side. So if I don't get to them or I can't catch up with them, sorry, they'll have to wait till next week. We may not have enough time this week anyway. I want to start this week's live with a mention of another case of terrible injustice. And that's the case of a young man called Ben Geen, who this day, today in 2006, was convicted and sentenced to a minimum of 30 years for crimes not only that he didn't commit, but crimes that didn't happen. Ben was a nurse and he was accused of causing harm that caused death to a number of patients in his care. Now, like so many of these so-called angel of death cases, they're centred around what they call a cluster of victims who have all died in similar circumstances. How do you make a cluster? Well, if you just look at the shifts as one person worked and look for similar deaths on shifts that that person worked, and you don't look for similar deaths on anybody else's shifts, or you don't look at shifts that he worked where there were no such deaths, then you have your cluster. These cases are horrific, and the sentences that go with them are horrific. Yes, Charlotte, Ben Geen. So I keep saying this didn't just happen to Luke, and there are so many others that need our help as well, need our support as well. So yeah, I'm thinking about Ben and his family today, and I just wanted everybody to be aware. Go have a look at the case. It's awful. Okay, now on to our update. And excuse me, I want to start this week with unintended consequences. As people, all of us, we don't know what we don't know. And we tend to talk about things as they should be or as we want them to be. But what we have to deal with in these circumstances is what is, not what we'd like to be, not what we think it should be, not how we wish it was, but how it is. And the reason I mention this is there's a couple of things that have brought this unintended consequences thing up. The first is the fundraiser for Corinne. Now that's come back up again in the last couple of weeks. And I want to make it clear, I'm not blaming anybody for posting Corinne's thoughts and comments. I'm not blaming anybody for that. The difficulty is, we all know that the money was being raised for Corinne to do with as she pleased. But the minute those words about wanting it put into an account for Luke were made public, they were reported to GoFundMe. And GoFundMe's rules, I don't make the rules, but GoFundMe's rules are absolutely 100%. They do not allow fundraising for convicted people. And I know that was reported very, very quickly because I had an email within a day or so saying that all withdrawals had been suspended. And I spent a week going back and forward trying to find a way to rescue the situation. But their rules are their rules, and that was the end of it. So there's nothing wrong. Of course, Corinne should be able to say whatever she wants to say, whenever she wants to say it. But in circumstances like that, that was the unintended consequence. And that brings me to the next thing. I've seen quite a lot of this in the last couple of weeks. And it's people talking about bombarding the prison governor, the Law Society, the Parole Board, the SCCRC with emails and letters and things like that. Oh, we seem to have, sorry, my screen just froze. There could be unintended consequences from doing things like that. So let me explain. The prison and the SCCRC and the parole board, to a degree, all have the ability to make very, very significant decisions in Luke's case. And if they are completely bombarded and maybe angry emails or things like that, annoyed people, seriously soft people, don't make good decisions. We know this. So bombarding these people, especially when at the minute there's nothing they can do. It's not the prison's fault they have Luke there. And, you know, they can't do anything about the fact that Luke was convicted. So bombarding them is not really the way to go. And I think part of this was in relation to Luke not being able to give an interview. Any chance there might be of Luke being able to give an interview with the prison's permission is likely to be damaged by that sort of approach. So all I'm saying is be a little bit careful. And if you do email these people, please stay polite and respectful. I know everybody's angry. I know people want their feelings to be known, but we need to do it in such a way that we help rather than harm any progress in the case. Okay. Now, next. Oh, yes. This has come up a few times, and it's understanding terms used in justice processes. And some of them sound similar, but they're completely different. One of the first ones that came up is the difference between undisclosed evidence and unused evidence. So let me try to explain. Unused evidence is evidence gathered by the prosecution that they don't intend to depend on once the case gets to court. So what they do is they put it in a big schedule, and the defence have the right to ask to see what's in that schedule, and they can use it if they want to. I'm going to come to that in a later point, but that's unused evidence, okay? So it's there for the defence if they want it. They have to ask for it. They have to make an application to the prosecution for it to be released, but it is actually there. Undisclosed evidence is evidence that the police investigation has not made known either to the Crown or to the defence. So an example in Luke's case is Stocky Man and the witness who came back later and identified him. That was never released to the defence. The defence knew nothing about it. Now, you would imagine that may at the time have been of assistance to the defence had they known about it. Normally, what they call disclosure failings, that's hiding evidence, at least play into or support the idea that there's been a miscarriage of justice, that there's been wrongdoing in the lead up to trial. In this case, it was dismissed by the SCCRC as not significant or not significant enough. So the point that I wanted to make here is the difference between unused and undisclosed. If there's evidence in the unused file that we find later after trial, after appeal, that cannot be used to take it back to the SCCRC. It's not new evidence. And the reason it's not new evidence is because, I've said this before, the definition of new evidence is that which was not or could not reasonably have been known at the time of trial. If it's in the unused file, it could reasonably have been known. The defence just needed to ask for it. But it's not that straightforward, because the unused evidence file, the way it's listed, doesn't necessarily tell you what the piece of evidence is or what its significance is. So you will have hairs. piece of fabric, piece of plastic on this unused schedule. Masses and masses and masses of stuff, and that's all the description you've got. When the defence applies for evidence, to look at evidence from the unused file, they have to explain why they want it and what they think the significance is. If you're looking at a list that says piece of plastic, piece of fabric, how do you know whether it's significant or not? So it's just another way that the defence is kind of hogtied in terms of the prosecution has all that evidence, it has all that information, but it's so difficult for the defence to access it. It used to be the case that they could just go along and look at everything, but that's no longer the case. Now they have to make an application and give a reason why they want to see it. The second set of terms is around forensic evidence, and this idea that everything that's gathered in an investigation is tested or should be tested. Well, that's not the case. The police investigation will choose which samples to test on the basis of what they think is going to take their case forward, to advance their case for the prosecution. Once again, here we have the prosecution, all the eggs are in the prosecution's basket here. They decide what to test, what to take forward, and what they think will support their case against the accused person. So not everything's tested, and only that they think will support the case is picked out for testing. Okay, so far so good. What about stuff that's not tested? The defence can, in some circumstances, ask for stuff that's not been tested to be tested. But in this case, the prosecution was not basing its case on DNA. So there would have been no reason for the defence to ask for particular pieces of evidence to be tested, because the prosecution wasn't saying DNA proves this, that, or the other. We know why. We know why they weren't saying that, because their case would have collapsed. But it meant there was no opening for the defence to go in and say, we want a second opinion on that, or we want this checked, or what have you. Fast forward to now. Is there evidence, or are there samples that could be tested now that may help to prove Luke's innocence? Yes. Yes, there are. But to apply for them, again, you have to give good reason. And I've said before, because this guy might be innocent is not good reason in legal terms. So what tends to happen in these circumstances is the courts decide that it's just a fishing expedition and refuse to release the samples. So getting the right reasons for asking for samples to be released for either retesting or new testing, getting the right reasons so that the court accepts those reasons is of massive importance, which is why we rely Luke's Fighting Fund to pay for the experts that can make sure we get that right, so that they don't just bat it off into the long grass yet again. Okay, so that was the two things that have come up, were the undisclosed versus unused evidence and random testing versus targeted testing. So I hope that explains a little bit about the difference in understandings of these terms. I got a really interesting question. Well, I thought it was a really interesting question earlier this week, and it's about the defence being able to gather their own evidence. And obviously there is an opening for the defence to do that, but obstacles to that, and in this case in particular, the most common obstacle in any case to the defence doing that is money. Legal aid funding has been slashed, it's been cut to the minimum, and the costs of defence teams going out and investigating and finding their own evidence and trawling through and all of that are enormous, and the money's just not there to do it. That's the first thing. Secondly, this case clearly kicked off for the police on the night of June 30th, 2003. They were gathering evidence and speaking to experts and doing all of that stuff right from the night of June 30th, 2003. And right up to the point where Luke was arrested the following April 2004. 9.5 months of gathering stuff. There was no defence team during that time. So the defence wasn't in a position to go gathering anything because there was no defence. So suddenly, on the 14th of April 2004, the defence is now playing catch-up on that 10.5 months. They get all the stuff dumped on them, and they have to decide, what do we use, what's significant, what's not, what's prosecution's argument going to be, what's the case going to be. All of that has to be done. Meanwhile, the police are still gathering what they're calling evidence. There's still masses and masses and masses of stuff coming in. So while the defence are playing catch up on the last 9.5 months, there's more and more and more information coming in. Now, what's interesting, or a bit of what's interesting about that, is so much of the stuff that was released to the defence was insignificant. It was irrelevant. But they still have to go through it in order to figure out what's relevant and what's not. And now the clock's ticking. So, for example, there was one statement in the files, and you need to have a bit of a sense of humour when you're doing this work. There was one statement in the files from a guy who said, "I've been asked to give a statement telling the police what I know about Luke Mitchell. I don't know why I've been asked that. I don't know Luke Mitchell." So that sort of thing, it's there, it's in the files, but they still have to plough through it all to decide what they need going forward. But the other thing, and this is quite unique to Scottish cases, and certainly to Luke's case in particular. In Scotland, back in 2003, once somebody was arrested, they had to be brought to trial within 110 days or be released forever. They could never be charged with the same crime again. So not only was the clock ticking from April 14th, there were only 110 days for the defence to get through all of that, decide what was relevant, what wasn't, try to make some semblance of sense from it, but they only had this 110 days to do it in. So you can see here, the prosecution, the police had a massive head start, and then the defence are running on catch-up. Something else that is interesting about the 110-day rule and how it happened in Luke's case, he wasn't brought to trial within the 110 days. He turned 16 just before the end of the 110 days, and therefore could be tried as an adult rather than a minor. But the trial didn't start, I think it was more than double. I think it was 224 days or something like that. So more than double the period that the 110-day protection, and that's what it is a protection, was supposed to safeguard, was doubled. And they held him for 200 and however many days it was before the trial started. So you have to wonder, what's the point of having these rules if they don't actually get used? So we have the 110-day rule that was just swept aside. We had the media protection where once somebody's arrested, they can't be named. They named him for 9.5 months, but once he was arrested, they couldn't name him, and yet 2 newspapers did. And the court still managed to find a way round it by saying, oh, well, he hadn't had his first appearance in court. Never been used like that before. From the point the person is arrested, that protection kicks in. Otherwise, it's useless. It's no protection whatsoever. It would have been no protection in Luke's case, obviously, because they'd been naming him for 9.5 months prior to that. But if there's no protection to be had, what's the point of having these rules in the first place? Okay. Oh yes, jury deliberations. The 5 hours of jury deliberations after a 42-day trial. Now, somebody pointed out that means the jury spent just 7 minutes deliberating for each day of the trial. At the time, it was the longest trial of a single accused in Scotland. It was massively, massively high profile. As anybody who was around at the time in this area would know, it was absolutely relentless. And the jurors returned the verdict within 5 hours. On the night of the 20th of January, the afternoon of the 20th of January, the jury was called, they'd retired round about lunchtime, and the jury was called back into court 3:30, 4 o'clock. And they said they were nowhere near a verdict, nowhere near. And the judge said, okay, go home, relax, don't think about it, don't discuss it, come back refreshed in the morning. He also said there had been cases in the past where there was a danger of maybe people trying to speak to jurors or contact jurors, and they'd had to be put up in a hotel away from everybody so that they couldn't be affected during their deliberations. But he saw no such risk in this case and thought it was perfectly safe to send the jurors home, and they would just go home and put their feet up and have a nice evening and come back the following morning refreshed, ready to start their deliberations again. What actually happened is they came back and within an hour delivered a guilty verdict. So again, the idea that the judge could even consider that there would be no risk, well, you can make of that what you will. The next 3 points I'm just going to touch on because one of them has come up, 2 of them have come up before, but just for clarity, because they've come up again recently, to begin with, there is a story doing the rounds, and it keeps doing the rounds because that's what trolls do, that I was connected with a charity that didn't file its accounts. Okay. I was connected with a charity and resigned from that charity before its accounts were due, and that was the end of my association with it. Whether accounts were ever filed or not, or whether they're even due to be filed, I have no idea. It was nothing to do with me. But this is an attempt to discredit this new initiative to set up Long Road to Justice, which is intended to help people like Luke, people like Ben, people like all of the others facing injustice in this country. And you have to wonder why anybody would have a problem with an organisation trying to do that. So that is the fact, those are the facts of the matter on that particular case. These people continually posting the idea that I somehow was involved with not releasing accounts to say where money had gone. Nope, didn't happen. I was long gone by then. The next one is graffiti. Now, I don't condone graffiti. I've made that absolutely clear. But I do think it demonstrates how angry people are, how frustrated people are. Not only that they're finding out all this information now, and that they should have known about it long before now. And they're furious. They're furious that this was done in their name. Not only that, but the fact that there's nowhere for them to go. That how do they make their feelings known? How do they make their anger felt at such a rubbish pursuit of non-justice? And it was a rubbish pursuit of non-justice for Luke and for Jodie and for everybody else involved. So I see the graffiti as an expression of that anger and that frustration. So no, I don't condone it, but I understand it. And yes, lots of people have been saying banners, chalk, things that can be removed. Yeah, great. Another way of expressing that anger and that frustration. Linked to that was somebody had said the petition's not going to do anything. There's no point in doing a petition. It's not going to do anything. On its own, no, it's not. It's not. Nothing on its own is going to make the difference that's needed here. But the petition is another way of saying thousands upon thousands of people are really unhappy with this and want something done about it. Add that to the protests, add it to, all of the other things that are going on. What we have now is an outraged, angry public. And I keep saying, the justice system, one of the things that the justice system tends to take very seriously is if it begins to consider that people are losing faith in it. People are losing confidence in it. And all of these things, the petition, the protest, the groups, everything is a way of saying these people are losing confidence and fast. And if you don't do something about it, even more of them are going to lose confidence as well. And then you have a problem on your hands. So, no, the petition on its own won't make a significant difference, but it will feed into everything else that we're doing that, when you add it all together, will make a significant difference. So please don't be discouraged by comments like, what's the point of a petition? A petition won't do anything. When I asked the poster, who I can't even remember who it was, who posted that, what would you suggest we do to take it forward? I had no idea. No suggestions, nothing. And I think, like a lot of you, I'd rather be doing something, anything, than sitting back going, oh, there's nothing we can do. It's terrible. What can we do? No, take action. Do something. Okay. I get a little bit excitable about the idea that we should just all throw our hands in the air and go, what a shame, and move on. No, that's why we're here now, because that's been happening for far too long, and it's time to do something about it. Right. Oh, yes. So there were two questions that were posted on some of the groups. Yes, Jill Thompson, protest. I agree. There were two questions that were posted on some of the groups, and a lot of people got really defensive really quickly. So one was, what if he did it? And the other was, I believe he's guilty. Convince me otherwise. Now, actually, these are really, really, really great opportunities to get the facts out. Again, and repetition here is key, because if we keep putting the facts out and keep telling people the actual processes and the actual things that happened, we reach more and more people on a very credible basis. So simply responding to these people, well, you tell me why you think he's guilty. No, whether it's a genuine question or whether it's a question designed to prod for a reaction. Give them the reaction. Here are the facts. This is a fact. 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 Give them the facts. And I saw a few people saying, well, I believe he's innocent and, nothing's going to change my mind. Yada, yada. Cool. But telling somebody you believe something is not going to persuade them. Because actually, for 17 years, lots of people were saying, I believe Luke Mitchell's guilty. And couldn't really give any reasons why. They just believed it. So we can't be replicating that in our fight to show people why he's not. So the idea here is tell people the facts, and don't be. There's no need to be defensive. The truth doesn't need defending. The truth defends itself. So light the mask and answer them with facts. And it's yet another opportunity for us to just get the story out there. Now, something that I think is important to mention. On Wednesday past, it was the 17-year anniversary of when Luke was taken from his home and has never gone back. And I have had lots of messages from people saying, how long do you think it'll take to get him home? It's taken us 17 years, nearly 18 years to get this far. This is a long, slow grinding process, whichever way we go about it. And I don't mean to dishearten anybody. I just want people to be aware. When I first started this, I thought, when Luke was convicted, I thought genuinely, in a year's time, it would all be sorted out. Excuse me. It would all be sorted out. We'd have the appeal and Luke would be home. A year. I would never have believed, if you told me back then, I would never have believed it would have taken this long just to get to where we are now. So please be aware. Hi, Rowley from Sydney. Hi. Please be aware that this is not going to be a quick process, even with all the support, even with all the new evidence coming forward. It's not going to happen overnight. I'm really sorry, but we need to be prepared for that. So yeah, it was just to make that point. Oh, so the grounding and ungrounding story. So Jodie's mum saying that Jodie had been grounded and she just lifted the grounding that afternoon, and Jodie was suddenly allowed out. And then the story from the other family members that said, no, it wasn't that night the grounding was lifted. It was a week previously or 2 weeks previously. I can't quite remember which. The point about all of this is when the police were pushing Luke to explain why he thought Jodie hadn't come out that night, and he was guessing. He was like, well, maybe she met somebody else. Maybe she just changed her mind. And one of the things he said was, maybe she was grounded again. And at trial, Jodie's mum said, she was asked, why do you think he would think that? And she said, I've no idea why he would think that. Well, there's 2 points here. Nobody can know why somebody else thinks something. That was a ridiculous question. How could anybody know what somebody else thinks or why they think it? But secondly, actually, Jodie's punishments were quite unexpected, quite sporadic. They were imposed and lifted with no rhyme or reason to them. So it was actually quite supportive of Luke's guess that she may have been grounded again, because these punishments were so unpredictable. And somehow that ends up being used against him. So I just thought it was quite an interesting point that somebody made about the grounding, ungrounding, and why did Luke say that he thought she might have been grounded? Well, because she might have been. Because these punishments could be imposed at the drop of a hat, and they could also be lifted at the drop of a hat, as explained by the story Jodie's mum herself told. She just suddenly decided, out of nowhere, at this very point, I'm going to lift the grounding. So, yeah. I saw something earlier, somebody asking about emailing prisoners, and I thought everybody understood this. Again, sorry, my apologies. The email a prisoner system, the prisoner's not sitting at a laptop getting your emails and emailing back again. They go to an office where they're printed off by prison guards and taken to the printed version, taken to the prisoner, and the response is done the same way in return. So you're not emailing Luke directly. And unlike letters, which in Scotland the prison guards can't read before the prisoner gets them, so that they're opened in the presence of a prison guard, the guard can't read them. So that's letters. Obviously, emails, if they're coming up on the screen and they're being printed off, they can be read. So again, just saying take a little bit of care about what you say and how you say it if you're using the email a prisoner system. So because I don't have anybody to do my questions for me this week, I'm going to see if I can look through your questions. Okay. Give me a second, it's all going too fast. Something about the SCCRC. The SCCRC are not fit for purpose. They're too close and aligned to the corrupt judicial system that operates in Scotland and do not act independently or impartially in dealing with cases such as Luke's and others. Well, it's quite interesting that the Westminster Commission on Miscarriages of Justice published their findings on the CCRC down there a couple of weeks ago, and they made quite a few comments about issues of impartiality. And one of the things that they spoke about was the reintroduction of lurking doubt cases as a ground for the Commission to accept an application. So lurking doubt is a case like Luke's, where it never goes away. It keeps coming back and it keeps coming back because there are so many unanswered questions. So if lurking doubt cases were allowed rather than depending entirely on new evidence, then that would be quite a significant change to the Commission in Scotland as well, if it was to apply in Scotland as well. And it would help cases like this where the passage of time in particular makes the new evidence thing quite difficult. I saw a question about calling out. Where was it? I think it was where Jodie's family calling out. Is Jodie's family sticking to the story that Luke did this? If this was my daughter, I think he'd be asking questions myself. I don't know. Jodie's family haven't commented, so I can't answer that. Was there any mention of the search party actually calling out for Jodie? Now, Jackie Henderson, that's a really interesting question, because according to their statements, so they left from Mayfield and they walked all the way down across the fields and what have you to the entrance to the path. And it took them 20 minutes approximately to get there. But according to their statements, they didn't call out for Jodie at all that whole journey, all the way down, and they only started calling out her name when they were on the path itself. Now, I've been criticised in the past for saying they didn't look for Jodie on the way to the path. Well, according to their own statements, they didn't look for her anywhere on the way there. They only started looking for her when they got to the path, and they only started calling out her name when they got to the path. And again, my question would be why? At that point, the information they had, or should have had, was that Jodie was supposed to be hanging out up here, Mayfield and East Houses. So logic would dictate that you would go looking for her in the places she was supposed to have been. So they didn't know at that point that she was going over to Luke's that night, according to all their statements. So this is not just my opinion, this is according to their statements. They didn't know that the plan was for Jodie to go down to Newbattle. They all believed that Jodie was and Luke were going to be mucking about up here, Mayfield, East Houses. And yet they walked through the entire Mayfield, East Houses area without looking any of the places she might have been, by their own admission, and didn't start looking for her till they actually got onto the path. Again, there may be an explanation for that. I don't know, because there's nothing in the files that asks them about it or says, why was that the case? There may be a perfectly innocent explanation for it, but I don't know what it is, because they were never, as far as I can see, they were never asked. Let me see. Is there a way of fundraising towards a retrial, Morag? No. We could. I've said before, if we set up Long Road to Justice, we then have the ability to raise funds for whatever cases we take on. As long as it's not one individual case, we can then divert funds to the individual cases that we do take on, and that would help to pay for things like lawyers and expert reports and people that can put in these applications to try to get back to the Court of Appeal. So that's the sort of thing we could raise funds for. But for a retrial itself, no, unfortunately, can't do that. When's the next James English podcast? I don't know, Stephanie. I haven't heard from James since he got back. I have been speaking to him, but sorry, I have been messaging him, but I haven't heard from him since he got back, so I don't know. If they didn't know Jodie was going over to Luke's, then why did Judith message Luke with a message for Jodie, assuming she was there instead of asking? I found that rather patronising. No, she assumed Jodie was with Luke. She had no idea where they might be. She just assumed that Jodie was with Luke. There's nothing that says she thought she was with Luke in Newbattle. Nothing. What will happen if and when he gets out? Will he be protected? Will this be the biggest miscarriage of justice in Scotland? Will he have to get compensation, and will he be able to live back in the area? Gosh, lots of questions there, Chloe. Compensation, very possibly not. The compensation rules were changed a few years ago, so very possibly not. And again, it would depend on how he's released. So if he's released as an innocent man, conviction overturned, basically that's it. He's out of prison on the street with whatever possessions he gets to bring with him, and a paltry payout to pay for bus fares or whatever, and he's on his own. He's on his own after that, if he comes out with his conviction overturned. So yeah, I think a lot of people think they come out and there's all this stuff to support them. There's not. There's actually there's no support for the innocent when they get out. So people who've committed the crimes, are guilty of the crimes, and have done their sentences, there's a whole process by which their reintegration back into society is facilitated all the way through. For innocent people whose convictions are overturned, none of that happens. And you'll see there are lots of people who've had their convictions overturned on Facebook in particular, Mike O'Brien being one of them, who will explain how that system works. So no, he won't walk out to a massive payout. Even if he did get compensation, it would be years down the line before that was decided. And something that a lot of people don't know, so I'm just going to mention it, is that when innocent people do get compensation after their convictions overturned, the state takes back a portion of that compensation to pay for their board for the time they've been in prison. I have no words for that one. Sandra, why was it not done at Glasgow High Court? Well, the defence did ask that the trial be moved away from Edinburgh on the basis that he couldn't possibly have a fair trial in this area because of the media coverage and the fact that the case had been so high profile. And the judge decided that as long as a jury from this area didn't come from the postcode areas of Dalkeith or have any connections with the two schools, as long as that was the case, the judge believed that a warning to the jury to put out of their minds anything that they'd read or seen in the papers would be sufficient to make the trial fair in that regard, rather than moving it somewhere else. So an application was made to move it, and it was refused on those grounds. Again, you can make of that what you will. No amount of money will give this young man his life back. No, it won't. And that's the really sad thing. People talking about huge payouts and everything. How do you repay 17 years? How do you repay the halt in life processes? Driving lessons, first pint, getting married, going to university, finishing high school. No amount of money can make up for that. None. Okay, I saw another one. In my opinion, there are now too many groups. Should only be a couple, as we're all after the same thing. Too much fighting and bitching. It's really sad for grown adults. If we're all on the same page and we're all aiming for the same outcome, it really shouldn't matter how many groups there are. If people stay sensible and keep their eye on the goal, which is getting the story out there, getting more support for Luke, and bringing public pressure onto the system. If all of the groups have that as their aim and stick to that as their aim, shouldn't matter how many groups there are, because, as you say, we're all grown adults. Can you please tell people the difference between the proposed group that you intend to set up and that of Mojo, as many people believe that Mojo actually investigates cases when in fact they don't, as Mojo is supposedly an aftercare service? Excellent question, Brian. Thank you. Yes, it's true. Mojo's remit is aftercare. Long Road to Justice, which is the organisation I started trying to set up about 2 or 3 years ago. The plan is to have trained full-time caseworkers who will stick with specific cases all the way through. Okay. Now, Mojo do have some volunteers who come in and try to have a look at case papers and what have you, but they are volunteers. They are very part-time, and unfortunately, because of that, they don't have the consistency to follow a case through from start to finish. that full-time caseworkers would have. The other thing is, there is no training course at the minute for people to do what I do. So because it involves having to learn so many aspects, so it's not just law, it's not just criminology, it's not just forensic science, it's not just how the police system works or how the court system works. You've also got to know all about how the media works and what the rights of the media are and what the rights of the individual are in relation to the media. So it's a huge area to cover. And there's no single course at the minute that trains people how to do that. The plan for Long Road is that our caseworkers will have that training and they will have access to guidance and mentorship, so that if they come across something they don't know, there's no problem with having some more training and bringing them up to speed on that. The other thing about Long Road, which differs from Mojo and other organisations, is that the idea for Long Road is also to provide a platform for people whose stories have never been told in full. So there are lots of people, and I discovered this actually when I was doing the PhD, there are lots of people who have told their story in fragments, in bits, because the police want this and the defence want that and the court wants this and the appeal court wants that and the experts want this. So it's fragmented. And I know that families take a great deal of value out of being able to tell their entire story from start to finish, of being heard, of being validated, and of being able to get their entire truth out there. And that's another aim for Long Road to Justice, is to provide that platform for people, whether that's in the form of podcasts, articles, books, however they want to do it. I want Long Road to be able to support them to do that. And then we have access for the wider public to this sort of information that you guys have started to see in its entirety since the 25th of February. Imagine having the access to that sort of information for all the different cases, all the different examples. And you can go in as a member of the public and see or hear their entire story. I think that would be a significant resource both for the families and for members of the public to learn about just what is possible. You remember I said at the beginning, you don't know what you don't know. And we assume that these things are done a certain way and certain things are allowed and certain things are not allowed. To be able to see these cases and to see what was allowed and nobody's ever questioned it, to see what was missed and it's never been allowed to be re-examined, I think would be a really important resource for, like I said, for the families themselves and for the general public. So those are the two sort of main platforms at the minute that Long Road to Justice hopes to achieve. It's ambitious, I know, and it will need quite a bit of funding, I know, but it's something that's needed. And the idea is that the caseworkers will have access to forensics experts, eyewitness experts. We can liaise with different groups. The Innocence Project in the States, which does all the DNA testing, would be a really, and they have already spoken to people who have said, yes, we will partner with you and support the charity, the organisation in that way. So thank you, Brian. That was a really interesting question, and I hope that's helped to answer it. We are almost out of time for this week. I'm not doing 2 hours because I missed last week. Sorry. Now, I'm new to this, so I might have been asked before. Was Luke ever offered any kind of plea deal? No. No. It didn't even come up, to be honest. It was The biggest argument was Luke wanted to give evidence in his own defence, and his QC didn't want him to take the stand. So it wasn't even a question of a plea deal. It was an argument about whether he should give his own evidence or not. Luke and Jodie need justice. Yes, Joanna, they do. Oh, I saw one about Sorry, you see, I'm having to read them this week. Who were the two family members that were staying at the Grands that evening? I'm sorry, I can't name them. They haven't been in the public domain. And I guess I need to explain this because I've seen a few things that are saying, why can some people be named and others can't? And it's actually as simple as that. If their names were brought into the public domain at the time of the trial or the appeal or the run up to both, then their details are already out there and that can't be undone. Naming people whose details were not out there at the time is a no-go area because you're then intruding into lives in much the same way that the media intruded and hounded the Mitchells. So if they hadn't been named formally in any processes around this, then I don't name them, and I've said before, I don't encourage speculation about who they are and what the connection is, because again, that's just doing exactly what was done to Luke back then. Sorry, just give me a second. I think I'm going to call it at that because there are loads of questions here. What I'll do is I'll take these questions and I'll condense them, and I'll start off next week by answering some of these. Does Luke know that he is supported on the outside? Yes, he does. Yes, he does. It's very strange after all this time to have so much support. So yes, he is aware. He does know. I'm hoping to speak to him early next week. Okay. We need to be outside the Scottish Parliament being loud and proud. Yes, the protest outside the Parliament had to be postponed, but I am speaking to people to see if we can get it reinstated at a later date. So we have the protest in Glasgow on the 3rd of May starting at 12:30. And like I said last time, as long as we all keep our distance and give them nothing to act on, then we can show them that a protest like that can be done peacefully, it can be done safely, and then we can roll on to one outside the Scottish Parliament after that. I don't intend on plagiarising your book, but would it be okay to quote selected passages from it? Graham, of course it would. Of course it would. Which brings me actually to something that I want to point out. Some people have been posting the entire chapter from my first book that was posted on a website. I think it's called the Fetis Conspiracy Forum, something like that. The entire chapter from my first book. Now, that was done without my permission. And I'm not being prissy about this. Please, please do not copy either the whole thing or quotes from it, because that was an early version and there were typos and errors in it that were corrected in a later version. So if people are copying that and posting that, then they're compounding some of the errors which only makes things more difficult down the line, because then I have to explain that that was a typo, that was an error, and what looks like more misinformation is out there when it's not. It's actually just a typo. I have been working on reproducing the entire chapter, corrected chapter, and it will be available to all of the groups, and I will put it up on both my Facebook pages as well, and people can quote from it as much as they like, but from that version, and I will put on it official version, not that other version, because it's just going to cause more confusion. Okay, so it's not that I don't want people to have the information. It's nothing like that. It's simply that I want the correct information to be out there always. Right. I'm going to call it at that for today. I will go through these questions once we're finished, and I'll take notes for next week. But once again, thank you all for joining me. Thank you all for all your support, for everything you're doing. It's absolutely fantastic. And I will see you all again next Sunday, same time, same place. Bye-bye.